And we are live.
Okay. What is this? Here we go. So, Michelle, would you walk us through the House passed version of the bill?
Sure. So for the record, Michelle Childs, Office of Legislative Counsel, and we're taking a look at H 173 as passed by the House, an act relating to prohibiting manipulating a child for the purpose of sexual contact. So the bill starts out with a purpose section. It is not codified. You'll see subsection A identifies some statistics regarding sexual abuse of children. Subsection B addresses the issue of what's commonly referred to as grooming, which is when someone methodically builds a trusting relationship with a child or young adult, the child or young adult's family, and the child or young adult's community for the purpose of manipulating, coercing, or forcing the child or young adult to engage in sexual activities. Subsection C explains that the behavior that is commonly referred to as grooming is termed manipulating in this act because while data shows that the LGBTQ community are no more likely to sexually abuse a child than non-LGBTQ persons, some folks have co-opted that term and weaponized that term. And so House Judiciary chose not to use that term in this act. Page 2, subsection D, some examples of manipulating behavior. This was compiled after House Judiciary took substantial testimony last year from various witnesses on the types of manipulating behavior. So again, that's just the purpose section. It's not codified.
Is there a difference between a purpose section and an intent section?
We tend to use them interchangeably.
Okay.
So, you know, there's a lot of different opinions of members in the buildings about intent and things like that, but it's essentially your choice as to where to go with that.
Thank you.
So section 2 is an amendment to your luring a child statute. So this is in chapter 64 on sexual exploitation of children. So your luring statute currently establishes the crime of knowingly soliciting, luring, or enticing a child under 16 years of age to engage in a sexual act. And you'll see the new term manipulate is added there. I will just let you know the Supreme Court in Vermont has upheld this statute as constitutional. They look to the plain meaning of the words that are used in the luring statute currently. With regard to, there's the knowingly mens rea there, and they've used the plain dictionary language for solicit, lure, or entice. So just a little background, because this will probably be part of the conversation. I looked up the dictionary definition for manipulate. It's to control or influence a person cleverly, unfairly, or unscrupulously, or to control something or someone to your advantage, often unfairly or dishonestly. So here would be manipulating someone under 16 years of age for the purpose of engaging in a sexual act or lewd and lascivious behavior. Then section 3, this is an amendment to sexual exploitation of a minor. So we just addressed this statute in, was it 694? And so I did make the change. You'll see in subsection A, that intro language mirrors what you've done in 694 with regard to the adding the sexual conduct to what's already there for sexual act to make sure you're being consistent. And then you'll see in subsection B, it's that no person who's prohibited from engaging in a sexual act or sexual conduct with a minor pursuant to A shall knowingly, and then it extends the language from luring into this statute. And so you'll note that this section.
That is extremely confusing. I'm confused now.
So if you think of it, section.
Who's prohibited from engaging in a sexual act is defined in 3251. Who is it?
No, it's
Who's prohibited from engaging in
It's
sexual
no
act?
person who's prohibited from pursuant to subsection A. So if you cannot be engaging in a sexual act or sexual conduct pursuant to A, you can also.
What is 3251 and what is 2821?
Those are the definitions. So 3251 is your definition of sexual act, and 2821 is your definition of sexual conduct. So you remember we've just been making those changes in other bills this year
Yeah.
to be consistent.
I'm totally confused here because I don't have those acts in front of me. And I'd like to read what it is that somebody is prohibited from doing.
Okay,
Of course, who's the people that are prohibited from engaging?
let me start with, so let's look at subsection A, current law,
Okay.
under 3258 for sexual exploitation of a minor. This is the statute that addresses when you have, essentially you have someone who is of the age of consent, so 16, 17, but they're a minor. It's prohibited for someone who is in a position of power or supervision over that child. And they have to have at least a 4-year age gap. That person cannot engage in a sexual act with that child. So let's say we've got a 16-year-old high school student and a 24-year-old soccer coach. So 16 is the age of consent. So because it's under 16, the other laws apply, but your current statute for sexual exploitation of a minor makes it a crime for the 24-year-old soccer coach to engage with their 16-year-old student. That's current law. So if you look at subsection A and you see the new language that's added on lines 10 and 11, so you recall we've had some discussion this year about in other places in law where it refers to a sexual act, like we were just talking about the sexual exploitation bill, which was H694, that DOC brought to the legislature's attention, saying that the sexual exploitation of person in the care and custody of the commissioner only applied to a sexual act, and sexual act definition does not encompass all the types of sexual behavior that they think should be prohibited. And so in 694, you added the language that's in lines 10 and 11 also to the sexual exploitation of a minor. So because right now, essentially what the statute does is it only prohibits a person, the 24-year-old, engaging in a sexual act, like a penetrative act with the 16-year-old. So now all I've done there is mirrored the language from 694. So I'm referring to the definition when I say 3251, that's the definition for sexual act. And then we're adding sexual conduct to make sure that you are also including masturbatory acts and other things that are not included in the definition of sexual act.
This is what we did in 278 too, right?
Yes,
okay.
correct.
And if I hope I'm right, because I have to report 694. This is also what we tried to address in 694 with the amendment around the Sentencing Commission to try and harmonize all of this. So it isn't so complicated.
Correct.
Okay, thank you for just helping me put all the pieces together. Because
Yep.
yes.
So that's just the prohibited type of sexual activity that is prohibited. And again, it has to be, you'll see in subdivision A2, current law, The actor is in a position of power, authority, or supervision over the minor by virtue of their undertaking the responsibility professionally or voluntarily to provide for the health or welfare of minors or guidance, leadership, instruction, or organized recreational activities for minors. And there has to be a 4-year separation. Okay, so it wouldn't apply to the 17-year-old student and the 19-year-old volunteer intramural coach or something like that. There has to be the 4 years and there has to be the position of power.
So both of those things.
Both of those things under current law. So if there was other types of things that might fall under sexual assault statute or something like that, it might fit. But in terms of this, there has to be the 4 years and it has to be the position of power that's identified in subdivision A2. So that's current law.
Okay.
Okay.
So now let's take that same scenario, the 16-year-old student and the 24-year-old soccer coach. Subsection B, because luring statute only applies to under 16. This statute addresses 16 and 17-year-olds because it says a minor, right? So, I mean, it would be anybody under that, but it's probably going to get charged in one of the other statutes. Most likely, it could be charged here.
I was going to ask you what's the difference between luring and manipulating.
What is the difference between it? I would look up the common definitions. I read you the definition of manipulate. This would be for the judge to determine. So subsection B is that if you are not permitted under subsection A to engage in sex, the 24-year-old and the 16-year-old, then you would also be prohibited from knowingly solicit, lure, manipulate, or entice the minor to engage.
Okay.
So that's kind of like the predicate to subsection A. So maybe they have not engaged in a sexual act, they haven't attempted to engage in a sexual act, but they've engaged in luring or manipulation for the purpose of dating.
So I think this might help to clarify things, but is this essentially making the crime of attempt in statute for this? Because it's the act of luring, but not completing the act to do whatever.
I mean, I guess I would ask the witnesses about whether or not how they would view that and using whether or not the attempt using attempts under the existing law is sufficient.
The first thing I'm worried about is this changes the term that I think people are very familiar with, which is grooming, into a term called manipulating. Am I correct?
Yes, well, the term is used to manipulate.
So I think there's a lot of information about what grooming behavior is. I'm gonna tell you that I think a 24-year-old soccer coach can be manipulated by a 16-year-old kid. Not necessarily for sex, but for pizza or whatever. So there's no magic here about who can manipulate either. The behavior is the grooming. But the House decided to call it manipulate, which I think is an unfortunate, in my view, doesn't describe what the behavior really is. It is grooming the child for the purpose of sexual acts or whatever, but grooming is well understood. Manipulating is, and working with kids for 40 years, I can tell you, they're very manipulative.
But the language is that it has to manipulate for the purpose of engaging in sex.
I understand that, but I never worked in a, I understand that, but it just doesn't seem right to me to change the terms that people are very comfortable with. Grooming behaviors.
I don't, I hear you. And I think it's that language has been incredibly politicized, and so I don't know that people are as comfortable or as understanding of what that means. I've certainly seen it leveraged in ways that don't mean what I think you and I would mean when we use that terminology, and so I understand why the House, maybe manipulated isn't the right word, but I do understand why they opted not to use that word.
But, I think the person who invites somebody to some young people between 16 and 17 over to their apartment, shows them pornographic videos and supplies them with alcohol or drugs is certainly grooming. I'm not, and maybe they're also, I guess you could use the term manipulating, but I'm not sure that the soccer coach, 24-year-old, who invites a kid over to his or her house has necessarily the intent of using it for sex. They may be, watching tape of the last game to go over. And so I'm worried about going from that scenario, which is clearly grooming, to another scenario. We heard enough testimony from in this committee and its former members heard an awful lot when we did the statute of limitations on sexual abuse. We certainly heard about the Catholic Church and priests, and we heard about other issues, and those clearly kids were groomed, and it's clear. But John, I'm not trying to be a sticky wicket here, but I just am concerned about unintended consequences. Senators.
Thanks. I think regarding your concerns, I hear where you're coming from, but when I look at page 4, line 2, and to engage in sexual conduct, if the coach is inviting the team over for a barbecue and they have a barbecue, that's one thing, but that 24-year-old is inviting 16-year-olds to come over and drink beer and watch porn, I feel like that falls into a different category, to engage in sexual conduct. I feel like, at least from the way I'm reading it, I feel like there's a pretty clear line, but that's my 2 cents.
No, I don't disagree, actually. My disagreement is with changing the word grooming to manipulating.
And that's just strictly a policy choice for you. I think in the findings, it's not about the, I don't think so. This is the one that I think, and I'll have to go back and look at the report, but the recommendation for having this type of legislation came from that study group that you established around the sexual exploitation of children in school settings a few years ago.
Don't get me wrong, I'm not.
And I was going to say, they used the term grooming in that
I'm not trying to speak against the intent of the bill. I don't have a better word than manipulation.
Right, no, I understand. I was just letting you know that they did use the word grooming in that report, but it was.
I thought that's what we were doing, is trying to get to that grooming stage, and perhaps the purpose is clear. What they said in A is clear. That's true. B is true. where I'm having a problem with C. Okay. Well, let's just move across the moment, see what we get. I thank you, Michelle. Didn't mean to question your expertise. Our first witness is Tim Lotters, legislative and assistant appellate attorney, Vermont Department of State Attorney.
Mr. Chair,
How are the sheriffs?
I have to ask that. Tim Leaders, Department of State Attorneys and Sheriffs. And yes, H-173, obviously a bill, pure policy type of conversation, testimony last year and testimony this year. And I'll largely track the testimony that I gave in the House. First, I think we appreciate the focus of continuing efforts to shine light on the child protection laws, and the, I think, well-intentioned purpose of excising or removing harmful politically weaponized language from statutes. This isn't a bill that that the state's attorneys asked for. And so sometimes we come in here and you see something like this and you might think that we had some request or something like that. And so we're not sure where it will fit in the field. It is important to note that the use of the term manipulate in the child luring context is in a series of ors. So they're not you don't need to entice and lure and manipulate. They're ors. There's kind of options for a prosecutor to pursue. And so, I was talking with the state's attorneys over the last few months about this bill. We haven't had many issues with pursuit of these types of crimes, but it's possible in the future there will be a circumstance that this could fit into. I just can't tell you that yet, if that makes sense. I just wanted to let you know that in looking at the purpose section, one historical piece of this bill in the last year or so is that the list that you see in the purpose section of what could potentially constitute manipulation, that was at one point in the bill in terms of the underlying statutory changes, and now it's in the purpose section. And we don't have a real position about whether or not it should be in or not in terms of the purpose section, but we actually are grateful that it's not in the underlying statute, in part because of some of the subjectivity and semantics of some of the list, which is a very well-intentioned and appreciated list, but it's not something that we think that the courts should probably sort out what manipulate looks like if you're going to include it in these statutes. Sexual exploitation of a minor and child luring. Is that clear? I'm basically saying the courts will have to sort out what it means, and that's okay, as noted by Attorney Childs. Luring, which I struggle to say with my Vermont guttural stop, but luring, according to the jury instruction, means to cause or persuade a person to go somewhere or do something by offering some pleasure or gain. Soliciting means to request or seek to obtain something, and enticing means to self-referencing, lure or induce. And so these are things that have been sorted out by the courts. And so if you were to add another word to that list in child luring, it would be sorted out in terms of where it's found in context if a prosecutor decided to pursue a manipulation theory of a case. They may continue to use luring, soliciting, and enticing as a point of practice. So I could report back in the future to see if it's actually come up in charging information, if that makes sense. I did want to note one piece, as Attorney Childs have noted, you have included in H-694 and the other sexual exploitation updates this year, the sexual acts or sexual conduct to constitute potentially a clearer list of the prohibited sexual behavior. In this statute, just as a flag, in the child luring, it's sexual acts and lewd and lascivious conduct, but not sexual conduct. If that's what, yeah.
I ask a question
Oh,
about this? So I looked at that and then thinking about lewd and lascivious conduct, and then I thought, well, do you need to actually add sexual conduct when you have L and L in that one?
The one, yeah, so the interesting thing, just as I don't have a real position on that, other than, as you're updating the other statutes right now, you may want to do that sort of copy and paste job, as you're doing with the other sexual exploitation statutes. Lewd and lascivious is something that changes with time, and it has to do with community norms. So it's kind of more of a moving target in terms of a definition. The other ones are statutory. And so just as a flag, and then as you go down to sexual exploitation, I think section 3 of the bill, you are including now sexual conduct and sexual acts, which we think is a good thing to do this year while we sort out what the definition may look like in the future.
Well, what's the difference between manipulate and luring in my example?
I'm not sure, I'm using the definition that Attorney Childs just used for manipulate. It's a potential theory to pursue, but I'm not sure where it would fit in right now. It's something that I can't say how prosecutors are going to use it yet because it's not in the statute.
40-year-old man invites 3 teenage boys to his apartment, shows them pornographic pictures, gives them alcohol. Is that luring? And then tries to have sex.
It certainly
Is that
could.
luring, or is that, because the guy's in jail right now, and he's gonna be there for a long, he was older than what I gave as an example, but he's gonna be there for a long time. Because he was already on probation for something else or parole. So is that luring? How did they get him?
Right, yeah, it must have,
I mean, this is 5, 6 years old.
Yeah.
So I don't understand. Do you want to charge him with manipulating too, or, I mean?
yeah, I think it would just be an individual case analysis. I'm not sure where it will fit in, if it will fit in. Basically, when we're looking at an affidavit, like in that circumstance, we would, prosecutors can become habit-based. And so if there's a prosecutor that's very used to charging a child luring case in a certain manner, they're probably going to continue to use the existing thing that they know, like luring, enticing, that sort of thing. If there's a factual circumstance where for some reason, either the judge says there's no probable cause for luring, enticing, soliciting, and they hadn't tried manipulating, I could see someone trying that, but that will have to be played out, and then it might be appealed, and then we can sort out what the word actually means. But there has to be a couple different tripwires for us to actually sort out what manipulate means according to the Supreme Court in Vermont. Until that time, we'll see if this were to pass, we'll see if people.
Does this bill give enough guidance to the Supreme Court as to what the legislature intended?
It would give actually, one of the main points of the testimony is that because that definitional list is in the purpose section, which I've been practicing as long as my colleague behind me, but it would seem a little bit novel to have such an exhaustive list as to a definition in the purpose section. That said, I would prefer that it's there and not in the underlying statute, because I would prefer it to be sorted out by the courts as enticing, luring, soliciting have been done. If that makes sense. So it's a policy choice about whether or not it needs to stay in there. I agree with you. The A and B in section 1, the purpose section, are I think well-founded and helpful and guiding. Once you get to that list, I think judges may look to that. It's hard to say. I've learned in speaking with Judge Zone, I'm never going to speak on behalf of any judge in Vermont, but prosecutors and judges and defense attorneys will have to sort out how that list may affect.
Judge Zone on this section.
Yeah. But, I think as to the rest of the bill, I think it's an entire area that we'll just have to kind of wait and see how it turns out.
Well, looking at the behavior, we did have testimony from the late Jerry O'Neill here about the Catholic Church, and those were all civil cases, but besides the fact of the behavior of the priests who he described, one was from out of state that came to Vermont for a retreat or something at a And looking at what he described as the grooming behavior, certainly they're, becoming a member of the child's family, for example, gaining the trust of the parents, gaining the trust of the other children, and then that behavior. That was grooming. Maybe it's manipulative. I guess it's manipulative.
Going to a point that Senator Hashim made, I think there is some of these circumstances that might be, we could charge attempt, right? Because it's not the completion of the act, but it's, and there's a definition of attempt that we talked about here before, but there's attempted luring, soliciting, enticing. That is another theory to pursue a criminal charge. Let's say that the sexual act did not occur, but everything else did, sort of the but-for situation. You could charge an attempt under current law, or under this new law, you could charge attempt. So that's another, I hate to say tool in the toolbox because I know it's overused, but attempt is something that can be utilized further upstream.
Are you supportive of H1 signature?
I think it's not something that during
Not you, I just
Yeah.
state's attorneys.
I've gotten sort of a mixed reaction, a sort of a wait and see reaction from the state's attorneys, and some of them have not responded to me at all on this issue. So that, I don't know if that's indicative or not. I think state's attorneys can be hesitant to, some state's attorneys may be hesitant to say no to something that may broaden something where they've seen a gap. Other state's attorneys like to know their statutes and like to know exactly what they say, and so this would be a change to that, and so that sometimes causes some wariness, but I haven't received very strong reactions in either direction.
What if a teacher sees real potential in a child, tries to work, but if the child is having all kinds of problems, tries to work with the family, builds a relationship with the family, and the child manipulates that relationship, and there's no sex involved, there's nobody intends for sex one way or the other, could they be charged with manipulating and grooming or grooming?
It would have to meet all the other elements, so off the top of my head, I'm just not sure, but
Well, maybe the kid says, that's why I don't want to see the person.
you were talking about charging the child?
No.
Oh, sorry,
Charging the adult.
Oh, okay.
I'm a little worried about it. I don't know.
It would have to be the adult allegedly manipulating the child
Yeah,
instead of
but,
the other way around, yeah, right.
but I look at A and B, you definitely know what goes on. But the intent of the teacher is nothing to do with sex. The intent is to have this person with high potential meet that potential. And suddenly they're accused of manipulating.
It would still need to be for the purpose of the facilitation.
Well, how would you, maybe the kid says that's what's going on.
Yeah.
Because the kid doesn't want to stay after school and be part of a debate club.
Again, yeah, I think I talked about it interestingly in the timber trespass context, but you would have to almost set up a chart of all of the cases where these have been charged to see if there was any gaps where, like maybe where a judge didn't find probable cause or where it was dismissed, to see if there was something to fit in there. I haven't done that big review for this bill, and it may be something that is not used that often or at all, or maybe something that prosecutors find a niche for, and where judges end up finding probable cause. That's how we'll be able to figure out what it actually means.
Right.
It's a hypothetical example for you. Let me know if you think that there's probable cause in this. So,
I didn't know this was going to happen today, Senator. I should have prepared a little bit better.
So let's say a teacher sends an email to one of their students saying, "Hey, I think you'd be great in the chess club. Come and play chess with the rest of the club after school." And that's all the email says. The kid, for whatever reason, really doesn't want to play chess, goes home, tells his parents, I didn't go to the chess club because I think my teacher's trying to groom me. The cops show up to the school, interview the teacher says, I have no idea what you're talking about. Here's the email that I sent the kid. We regularly have chess club. Would there be probable cause to charge the teacher with luring just because the kid is saying to his parents, I think the teacher is trying to groom me?
I mean, I wouldn't find probable cause for that.
Thanks.
Yeah, I wouldn't pursue a charge on that. I think you would need more than just, yeah.
Put an aggressive prosecutor.
Yeah, I mean, you should, sure.
No,
Yeah.
seriously.
Yeah, no, in terms of the elements, right? So you have the defendant who's the teacher, the solicitation or luring or enticement is maybe the email, and then the engagement in the sexual act or lewd lascivious act would be that child saying, if they understand what the word grooming means in that context, or manipulate in this future context, that would be a really important, the most important piece of evidence would be the child actually explaining why they felt that way. Was there other things that the teacher had done or exposed them to or said that made them feel like there was some sexual act or desire in terms of the intent of the teacher. And then it would be at the time of the offense that the child was, the different age requirements for the child learning. But it would depend, you need a little bit more for what the child actually, why they said that word to their parents, grooming or not. And grooming is not in the statute. It's something that I think, as explained very well in the purpose section, is something that is a conversation that has been politicized and weaponized against people. And we have seen that on the other side of things too, with criminal threatening and acts of violence against individuals who are in those categories as described in the bill. But I'm sorry, I'm a bit neutral on this. I know you're maybe not used to that in this committee, but
No, we're not. No, we're not.
Yeah.
I'm hearing the neutrality.
Yeah.
Thank you. Any other questions for Mr. Waters? Thank you, Tim.
Thank you all.
Always a pleasure to see you here.
You too.
Pleasure to see Marshall Paul right behind you.
Welcome.
And we'll see if he's as strongly in favor of this.
So, Marshall Paul from the Office of the Defender General. And as far as our enthusiasm for the bill, I have to echo Attorney Wooters-Dumont. We don't support this bill, but we also don't oppose it. From our perspective, this bill doesn't criminalize anything that's not already criminal. Everything that this bill allows the prosecution of could already be prosecuted either directly under the luring statute or under, as attempted sexual exploitation of a minor, attempted lewd and lascivious conduct with a minor, attempted sexual assault on a minor. We think that all of that pretty well covers it, and that frankly, there's not enough sort of a gap. We've looked at several different dictionaries' definitions of manipulate, and then sort of tried to fit that in with the entice, solicit, or lure, and really couldn't dream up many scenarios where somebody was manipulated but was not enticed, solicited, or lured. That pretty much every manipulating scenario we could come up with also involved stuff that would fall under the definitions that are used in the jury instructions for entice, solicit, or lure. So we don't have any concerns with adding the word manipulate in there. We do have some concerns about in section 3, subsection B, which this is one that we don't have any concerns with the substance. It's just the section itself is written in a way that's really hard to understand. We passed it around the office and had people try to understand it. We even tried to diagram the sentence and couldn't diagram the sentence. It's a lot of modifying clauses layered on top of modifying clauses layered on top of modifying clauses, such that, for example, it was very confusing for some people reading it to figure out who was prohibited, because there's so many modifying clauses between who was prohibited and pursuant to subsection A, which pursuant to subsection A is the language that tells you who is prohibited, but the two are separated by, 3 lines of text and several more modifying clauses. So that section we would suggest should be rewritten into at least a couple of sentences. It's a really long run-on sentence. And at the very least, the words pursuant to subsection A should be moved directly after who is prohibited. So it would read, no person who is prohibited pursuant to subsection A from engaging in sexual acts as defined by, et cetera, et cetera. I think that would make it a lot more readable. But altogether, that one section is just very wordy and complicated, and it's hard to, you really have to parse which clauses are modifying, which clauses are modifying, which clauses. So that's our only concern there. Other than that, we're not really concerned about the substance of the bill. If anything, this gives us another offense with a lower penalty than some of the other offenses I mentioned, such that, because some of those other offenses I mentioned, attempted L&O with a child, for example, have a really high penalty. This has a penalty of a 6-month penalty or a 2-year penalty, depending on which section is violated under the exploitation of a minor. Luring is left alone. I forgot what the penalty is on that, but that's in a separate statute. So I'm happy to answer any questions.
Thanks, Marshall. My question for you, and I apologize if I missed it, but so is this essentially, let me backtrack. I think you had mentioned that everything that's described here can already be charged under existing law. Is that under, if you go up earlier in the page, lines 3 through 5 on page 3, the section applies to solicitation, luring, and so on?
Yes, but also other offenses. I mean, I think that sometimes, like, we dreamed up some scenarios where it wouldn't quite fit under luring a child, but it would fit under attempted lewd lascivious conduct with a child. So I think there's sort of a multitude of offenses there. And interestingly, you don't actually have to charge attempted as a separate. So most statutes you charge attempt separately because attempt is section 9 or section 11. But the luring a child statute actually has attempt built into it. So if you look at the beginning of the luring a child statute, it says, no person shall knowingly solicit, lure, manipulate, entice, or attempt to solicit, lure, manipulate, or entice. It's sort of an oddly constructed statute in that way. Most statutes in Vermont don't contain a built-in attempt section because we just rely on the attempt section that our independent attempt section. I don't know why it ended up like that. I did a little bit of research, but could not figure out what the legislative purpose was of having attempt in there.
I don't understand the purpose.
That was actually going to be my exact next question. I know it's something that you might not be able to answer, but any thoughts on what this bill is trying to fix? Or any gaps?
I don't know.
Okay. Thank you.
Can I go to the penalty section, which I hadn't focused on earlier, admittedly? So current law, any of the things that are in this bill except manipulate, the penalty is not more than 5 years and 10,000. But now, person violates subsection B, which is all of that. It's not more than 6 months, not more than 1,000, and the person with a power of position of authority is 2 years and not more than 5,000. And I find it fascinating that the House is actually lessened the penalty for a violation
You're looking
by a person in power of authority, because it's not specifically, could be luring, could be anything, right?
Well, we're looking at two different sections. There's,
Well, that's
3258, which is sexual exploitation of a minor.
Mhm.
And then there's 2828, which is luring a child. 2828 does not have its own, penalty section built into it. If you give me 1 second, I can tell you the penalty for luring a child.
Luring only applies to under 16 as well.
And the penalty for luring is,
So if the child is over 16 or 17, they come under this. But if it's luring, it's only under 16.
Yes.
And this penalty is only if you do it to 16 or 17-year-olds?
It doesn't cut off at 16, so there is the option to charge if it was a
So
15-year-old.
if the kid was 14, the kid was 12, and somebody in the soccer coach, it's middle school, and so the child is 12 and he's 24, and he does all the things you described,
No, they can charge them under luring.
or they can charge him under manipulating and get not more than 2 year, which is a misdemeanor.
Yeah, but I think as Tim was talking about, so, and Marshall as well, there's multiple statutes there for the state's attorney to be able to choose depending on the facts of a particular case. So it may qualify as a sexual assault, it may qualify as luring, it may qualify as an attempt, it may be sexual exploitation of a minor.
My personal point of view at this point, and I need to be convinced by future witnesses, why would we do this bill? Why would we lessen the penalty? Why would we do this?
I don't have an answer for that, but
I know you don't.
I can answer the question of what the penalty is for luring, because that is in a separate statute. The penalty for luring is 5 years and a fine of not more than $10,000
Right.
or both.
And now we've got 2 misdemeanors.
In a separate statute,
So
sexual exploitation.
You might
statute.
argue if your client is charged with manipulating, that it should be your client was manipulating, not luring, and therefore it should be the misdemeanor.
I'm not sure exactly how that would play out, but
Well, the courts haven't defined manipulating yet.
I do think that there are cases where the defense could ask for a lesser included instruction and try to get the lower penalty. I can picture circumstances that would lead to that.
Thank you. Are there other questions for Marcy? Marcy,
Hello, thank you for inviting me.
Hi, Marcy.
For the record, Marcy Hambrick, Prevent Child Abuse Vermont. I'm the Director of Research and Programs in Child Sexual Abuse Prevention. I am here today to encourage you to take up H-173 to expand the statute prohibiting luring a child to also prohibit manipulating a child to engage in sexual activity. I have 3 points to make today. Firstly, that the act of manipulation for sexual activity causes additional harm to the victim, aside from the harm of the sexual abuse. Secondly, that manipulation and luring are distinct acts. And thirdly, that legislation like this has been successfully implemented in other states to keep children safer. Research by Winters and Jellick in 2022 found that victims of sexual abuse who also endured manipulation prior to and during the cycle of abuse experienced, quote, more psychological manipulation, thus leading to more feelings of confusion, culpability for the abuse, guilt, and shame, unquote. And that as a result of the manipulation, were less able to disclose abuse, which blocked pathways to access interventions that help a victim heal. Additionally, researcher Culiara and colleagues found that when family members had been groomed, children's disclosures were discounted so that protection was less likely, and that's from a study in 2014. Clearly, manipulation behaviors, often referred to colloquially as grooming, exact a separate and worse toll on victims of child sexual abuse. Research by Wolf and Pruitt in 2019 with adult survivors of child sexual abuse found that offenders manipulate the child victim to, quote, doubt the perceptions and experiences, unquote, that they may know that they're experiencing harm and be convinced by the offender that there is no harm. Part of the manipulation is convincing an impressionable child that if they seek help, they will be blamed, punished, or not believed. Additionally, offenders often confuse children to view the offender as a victim who should be shielded by the child from blame for their actions. Those researchers also found that verbal coercive manipulation was associated with statistically significant worse PTSD symptoms experienced in adulthood. Manipulation that included threats was associated not only with worse PTSD symptoms, but also with worse anxiety, depression, sleep problems, and dissociative issues in adulthood at statistically significant levels. Let me share with you some voices of victims from the study by Plummer in 2018 to help you understand what manipulation can look like in real life and how this affects a child. One victim said, quote, I was spending less and less time at home, more and more time with him, and the trips continued, the water skiing continued. I drifted away from my church. I stopped going to Sunday school. My school grades declined, unquote. Here is a description from another victim, quote, here is me, young and naive, and he's giving me things I couldn't imagine, going out for a trip, food and things. It's more affection than you get from all of the rest of the world. It makes sense that you go after those things, unquote. A third quote from a victim, quote, in the process of that as well, he became a friend to the family. I remember over a period of time, he gave my parents a new stove and things like that, unquote. A parent of a child who discovered that an adult had been manipulating her 14-year-old child for 14 months shared that without any legal recourse, she felt livid, angry, terrified, and also helpless. Although the legislature has already seen the importance of criminalizing luring a child to engage in a sexual act, manipulation is different in that it is a process that can last years. Evidence of luring is much more proximal to the sexual crime. But manipulation, which is much more deleterious than luring in terms of negative victim impact, as we've seen from the research, would be evidenced months or even years prior to the act of sexual abuse. You can see from the quotes from victims that manipulation can involve socially isolating a child and the offender ingratiating themselves to the child or to the child's family over an extended period of time. This results in cognitive dissonance when the abuse occurs and increased psychological harm. Other states such as Texas and Indiana have successfully enacted this type of legislation. Vermont has long been known for acting swiftly to protect children when new risks come to light. This is another one of those moments. Since manipulative practices used by offenders who sexually abuse children cause harm that compounds the negative mental health repercussions of the sexual abuse alone, society and specifically our children should be protected. Criminalizing the act of manipulating a minor for sexual abuse will give the court a way to punitively address the added harm to the victim. Children do not have a voice, and you can be that voice by taking up H-173. And I'm here for your questions.
Any questions for Marcy? Marcy, thank you very much for the testimony. We appreciate it. It's well written and well researched. Thank you. Do you have any comments on our discussion and the discussion of the state's attorney and sheriff and the defender general?
Well, I'm hopeful that some of the examples that I brought forward that are actually from research may have helped to clarify the difference between manipulation and luring. And if you still have, questions about that, I'm willing to engage in conversation with you about that.
Well, and you may have to come back for this question, but are you concerned that that there's two different penalties now for luring, that the penalty sections of the bill seem to be in conflict with the bill?
So I think if you decided that was a conflict, you could address it as the policymakers.
I'm asking if you think it's a conflict. Does Prevent Child Abuse Vermont believe that's a problematic area?
I believe that under luring, they could not bring some of the things that happen forward in court. And so I believe that adding manipulation broadens the scope of what can be charged. I know there's been some disagreement about that, but we definitely believe that manipulation and luring are two distinct different acts, and that there could be situations in which the use of manipulation might be something that happens when luring does not. And so that would give more options to prosecute. And so with regard to the sentencing, that's really something that would be up to you and the committee to decide.
Thank you. Any other questions? Marcy, thanks so much for joining us this morning.
Thank you for inviting me.
Did you complete it?
Earlier?
Okay. Did Ben email it to us?
I emailed
Yeah,
directly
just,
to you all.
I saw it in my.
I haven't looked at my email.
Printing out hard copies.
Okay,
Will you let me go get Senate approved?
yeah, but can we vote on it?
On what?
Yes, it has been seen by the editors. I sent it out.
40.
I don't know whether or not Senator Bloom.
Which is
After reading that,
Yeah.
physical abuse has to be present for tort action, whatever. So what are we accomplishing here?
This is Michelle's. This is yours.
What's that? What was that, Senator?
I was just reading that in reference to page 40 under the civil actions, whatever else. If someone's to bring a tort complaint against someone else, generally speaking, just go through on its own merit. There has to be physical abuse or something that can be proven also. That's the way that I read it.
There's other torts that don't involve physical abuse as well, like intentional infliction of emotional distress is one of them.
Possibility. I think it's a stretch,
What do you think, like the jury instructions for luring? Interest or? I just wasn't sure if you wanted a copy of the jury instructions for luring. It was,
Yeah.
talks about some of the definitions.
Senator Bruce is not in this office.
Okay, so we'll just vote for this and then get his vote later.
Thank you.
So everybody should have a copy of draft 2.1 for the amendment. All I did was restructure subsection A. So no person shall intentionally and without consent remove or tamper with a condom prior to or during a sexual act in a manner likely to render it ineffective for its common purpose when consent to the sexual act is given by the other person with the explicit understanding that a condom would be used. So that's the one change.
How's everybody think?
Fine.
Somebody want to make a motion?
I move that we find draft 2.1 as H40 change for
Senator Bahowski has moved that we report H 440, draft 2.1 favorably as amended. Is there any further discussion by anyone? Hearing none, Matt. Matt, would you please call the roll?
Senator Norris.
No.
Senator Kowalski.
Yes.
Senator Shi.
Yes.
Senator Zeus.
Yes.
And then Senator Bruce.
Yeah. Who wants to report it? Anybody? I mean, I don't mind doing it.
I guess you can do this one.
Thank you so much. Michelle,
Yes, I will.
I don't need exhibits for my floor.
Okay, but Sure, I'll put a little.
Just a little note of what we did and how we
Sure.
changed it.
Yep, no problem.
And then, Ben, if you would get Senator,